The Property Rights of Spouses Act, Part 2, Family Home. Section 6, Establishment or entitlement to family home. Subsection 1. Subject to subsection 2 of this section and section 7 and 10, each spouse shall be entitled to 1/2 share of the family home, A, on the grant of a decree of dissolution of a marriage or the termination of cohabitation, B, on the grant of a decree of nullity of a marriage, C, where a husband and wife have separated and there is no likelihood of reconciliation, so here each will be entitled to half the property, half the value. If they divorce or if they work in common law and no longer cohabit, or if they are separated, but the part C seems to be saying that they are separated but not yet divorced, but yet are entitled, each would be entitled to half the value of the property of the family home. Subsection 2. Except where the family home is held by the spouses as joint tenants on the termination of marriage or cohabitation caused by death, the surviving spouse shall be entitled to 1/2 share of the family home. So, except where the family home is held by spouses of joint tenants. So this seems to be saying that if they were not joint tenants living in the home, one dies, then the other would be entitled to only half share. If they were living together in the home, the surviving partner would be entitled to the, probably under normal circumstances, to the full share of the family home. But if they were not living together as joint tenants in the home, then the surviving partner would be entitled to only half share, where what would happen to the other half? It's a question in my mind, but we continue to read. Section 7, subsection 1. Where in the circumstances of any particular case, the court is of the opinion that it would be unreasonable. Well, let me say section 7 is the power of court to vary equal share rule. Okay. Subsection 1. Wherein the circumstances of any particular case, the court is of the opinion that it would be unreasonable or unjust for each spouse to be entitled 1/2 of the family home. The court may, upon application by an interested party, make such order as it thinks reasonable, taking into consideration such factors as the court thinks relevant, including the following. Okay, so one party might apply for variation of the equal share rule. The court says your husband or your wife is entitled to half the share, and you believe it should be only 1/5, 1/10 of the share, then you can apply to the court Now, the court may consider this, and relevant consideration would be as follows: that the family home was inherited by one spouse. So one person inherited the family home from their parent or grandparents or some other relative. B, that the family home was already owned by one spouse at the time of the marriage or the beginning of cohabitation. So they didn't buy the house together. One of them was already the owner before they met or before they got married. C, that the marriage is of short duration. Okay. So they were married for only a year, maybe a 2 year, and then divorce, and all of a sudden one spouse want half share in the family home. Subsection 2. Subsection 1. In subsection 1, interested party means, so the interested party who might receive their share or who might apply to the court for part of the value of the property. The interested party means a spouse or a relevant child or any other person within whom the court is satisfied has sufficient interest in the matter. Okay. So could that be a woman who the husband was keeping on the side for all these years? Could it be a man who the wife was keeping on the side for all these years comes in and make their own application to the court? Could that be? But anyway, the judge would have freedom in considering who the interested party might or might not be. Could be a relative, cousin of one of them. But anyway, to continue. Section 8. Transactions to defeat interest in family home. Subsection 1. Where the title to a family home is in the name of one spouse, only then, subject to the provision of this Act, A, of one spouse only. Let me read that again. Where the title to a family home is in the name of one spouse only, then subject to the provisions of this Act, A, the other spouse may take such steps as may be necessary to protect his or her interest, including the lodging of a caveat pursuant to Section 195 of the Registration of Titles Act, and B, any transaction concerning the family home shall require the consent of both spouses. So if it's a family home and the title is in one of their names only, but one wants to have it put up as collateral for a loan or wants to sell it, both of them would need to consent. The one whose name is not on the title would be able to prevent such transaction. If they disagree, they would need to consent to such transaction. All right. Subsection 2. the court may dispense with the consent of a spouse required by subsection 1b if it is satisfied that consent cannot be obtained because the spouse is mentally incapacitated or the whereabouts of the spouse are unknown. So the person is mentally ill or they cannot find that person, or consent is unreasonably held, or for any other reason consent should be dispensed with. So one spouse might be unreasonable. The court finds that the spouse withholding his or her consent in that transaction is just being spiteful. So the court may overrule that refusal to consent to the transaction and let it go ahead. 3. Where one spouse enters into a transaction concerning the family home without the consent of the other spouse, then A. Subject to paragraph B, that transaction may be set aside by the court on an application by the other spouse if such consent has not been previously dispensed with by the court. So the main transaction here seems to be where upon dissolution of the marriage or cohabitation, the house is to be sold and the money shared equally among them, and one of them refuses to sign the document for the sale of the house. So in that case, the court, if one of them is just being spiteful by refusing to consent, the court may overrule it. Alright. Subject to paragraph B, that transaction may be set aside by the court on an application by the other spouse if such consent has not been previously dispensed with by the court. B. Paragraph A shall not apply in any case where an interest in the family home is acquired by a person as a bona fide purchaser for value without notice of the other spouse's interest in the family home. Paragraph A shall not apply in the case where an interest in the family home is acquired by a person as a bona fide purchaser for value without notice of the other spouse's interest in the family home. So it seems as if somebody else buys the house and a bona fide purchaser for value without notice of the other spouse's interest in the family home. That means maybe the home values $10 million and somebody buys it for the $10 million. Then paragraph A shall not apply. So paragraph A says, subject to paragraph B, that transaction may be set aside by the court on an application by the other spouse if such consent has not been previously dispensed with by the court. But somebody else buys the home. No. In that case, paragraph A does not apply. Alright? 4. Where by virtue of subsection 3, oh, by the way, 10 million, a house may be valued 20, 30 million. It could be. But anyway, we continue. Where by virtue of subsection 3b, That's here, subsection 3b. A transaction cannot be set aside by the court. The spouse whose interest is defeated shall be entitled to claim out of the proceedings of the transaction the value of that spouse's share in the family home. So if the house is sold for say $30 million, let's say $30 million, each spouse is entitled to 15 million, and one of them, right, would therefore be able to claim for that 15 million, whatever the case may be. All right. So basically, there is an equal share rule. Automatically, each spouse is entitled to half the value of the family home, but it may be varied by the court. There is provision to vary it by the court under these situations where we saw earlier, where one of them inherited it, or maybe the marriage was of short duration, and so on and so forth. Section 9, transfer of interest in family home, exempt from transfer tax. An interest in the family home which is transferred from one spouse to another spouse, or from one spouse to both spouses, or from both spouses to one spouse. So here, an interest in the family home which is transferred from one spouse to another. Or it could be from the husband to the wife, or the wife to the husband, or from one spouse to both. So maybe both of them have interest in it, or one has interest and the other doesn't. So that with the interest in the house, give part of that money to the other, and they take part for themselves from one to both spouses, or from both spouses to one spouse. So one of them may give up their interest altogether and just transfer it to the other person, right? Pursuant to the provisions of this act, shall be exempt from transfer tax under the Transfer Tax Act. We will next look at Part 3, property.